The topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert Show on W4CY Radio and Talk4 TV, where we bring you educational information from experts on such topics as legal, health, financial, and home improvement. Now sit back and listen to our experts in community association law, estate planning law, tax relief, Medicare, public insurance adjusters, neuropathy treatment, business brokers, and personal injury law, along with many other topics. Now here's your host for the last 17 years, Steve O.
Morning, Tampa. Welcome to another Ask the Expert show where we bring you the finest experts in the field of legal, health, financial, and home improvement. And yes, that's right, 17 years we have been doing this show. And I got to tell you, our first expert this morning is definitely one of my favorites. It's an area of law you've got to have a heart. You've got to understand people. You've got to be able to communicate with people. I think it's like no other area of law. Let me introduce you to our great attorney, our estate planning attorney, Attorney Debbie Baker. Good morning, Debbie.
Hey, Steve. I love when you introduce me. It's so great. So what's our topic for this morning, Steve? You just got a bunch of questions.
Listen, Debbie, we've got all these new listeners now and viewers from TikTok. We got to tell them about your firm.
Oh, okay. You guys tell me. All right. So I've been practicing law now. Well, I graduated from law school in 2015, and the introduction says Steve's been doing this for 17 years. So he started when he was 17 and he's still 17, that kind of idea. He's gained a little weight since he was 17. Not too bad. so in any event, I've been practicing now for just about 11 years. I went to law school as a walk of faith. I got pink again. I've been an executive coach for 30 years, helping people make tough decisions about their professions and stuff. And by the way, for everybody watching, I have no control over what just happened to my picture. So, and I do estate planning because it's just a way to continue to be of service. God told me to go to law school. Amazingly, it'll be almost 18 years ago. And on August 22nd, will be 15 years since I started. But it's been this glorious walk of how do I help people move through situations where they can plan in advance to spare their families the grief, some of the grief they might encounter if they don't plan. So estate planning, probate, which is wills and trusts, and elder law for government benefits and asset protection planning. And it's just all a joy to do. So that's a little bit about me. And I'm purpler than I usually am when this screen goes pink. So anyway, so that's a little bit about me.
Debbie, I got to add this in because there's a lot of people out there who will go, I'm too old to change professions now. And I got to say, you did it.
Yeah.
Unbelievable. You did it.
Yeah. I was very disappointed when I went to law school to learn I wasn't going to be the oldest person who ever graduated. I never asked how old that person was because they were older than me. But for people who say they're too old to do something, you really have to look. If you want to do it badly enough, you'll find a way. And law school was absolutely one of those things. When I went to law school, it was the third or fourth time I thought about it, and it was the perfect time. It was the perfect time. So if you're sitting in a world or you've got young people who don't know what they want to be when they grow up, they've got their whole life to grow up, so to speak. If you got something you want to do, just go do it. Find a way, or just stop berating yourself because you're not going to do it, because there's nothing gained in that either.
Debbie, I cannot believe we've been doing this show. I think, over 2 years now with you. And I can't believe we still get many of the same questions. And I went through all the questions that were asked over the last 3 or 4 weeks since your last show. And I got it. It's still about wills. People do not understand about a will. Do they need a will? Does that keep them out of probate? Let's talk about that.
Okay, so wills, thank you. I spoke to a guy last week, actually, who's a patient advocate, and totally, kind of different subject. He has a power of attorney, he has a living will, but he doesn't have a will. And I said, why don't you have a will? He said, I don't own anything. I said, here's the thing. You may not own anything. He's from a divorce, and his children are very well established, I gather. And he's got grandchildren. And I said, well, here's the thing. If you don't have a will and something happens to you, if you pass as a result of a malpractice suit, or you pass as a result of a person, like a car accident or something like that, you need something in place for your estate to take the settlement. And if you don't have something in place, if there's a settlement, it goes directly to your children. He said, I don't want my children to have it. I said, I understand that. You made that very clear. So a will is the document that will allow somebody to administer your estate, whatever that is, whether it's just furniture and fixtures and books, or it's a small bank account, because you've given them the right. If you don't have one, then by law, people may get your estate that you never wanted to have it, either because they will never need it, or you don't like them anymore. If you've done planning correctly, the will is there for that thing that you couldn't foresee happening, like that malpractice suit or the personal injury suit, to collect whatever proceeds may be due you, but you're not here to collect it. So a will is it's just essential as a catch-all if you've done your other planning, or as a minimum, so you've named the person you're going to trust to execute your wishes after you pass. It does not prevent probate. So if anybody listening has a will, and in their will they say, I want my home to go to Steve and Sophia, who are your children, that's great. But they'll have to go through probate to own the home. The will itself will not get them your bank accounts. The will itself will not get them your home. The will itself will not get them your retirement accounts. It will say who does, which is good. And it won't do it directly. So a will is a foundational ingredient. If you have $500 in the bank, you need a will. If you have anything personal that you want to go to somebody and you don't want to give it away before you die, you need a will. If like this gentleman I was talking to knows he wants whatever he has when he dies to go to his grandchildren, he needs a will, so it goes directly to them versus going to his children first, and then they have to give it to the grandchildren. But wills are an essential foundational piece of a plan. And if that's all you have, it's certainly better than nothing.
So what's better when there's minor children involved, a trust or a will?
I'm a trust, in my opinion, because children can't inherit money till they're 18. Most of us couldn't handle whatever the equivalent today of $20 was when we were 18. Well, most of us are not taught that. And you want to be sure that your children are in a good place to get it. So when you do a trust, you can say that nobody inherits, whether your children or grandchildren, if there are substance abuse problems, if there are creditor problems, if there are marriage problems. And the trust is the instrument that distributes your assets as you've chosen in advance to distribute it. If you leave everything outside of a trust, and everybody you know who's a beneficiary is over the age of 18, let's say, when you pass, they can get all of that money outright, and that may not be the best thing for that individual. They may be irresponsible. Biggest thing is they may not be responsible with money. And I had one friend whose mother-in-law left both of my friend's children $100,000 apiece when the grandmother died. And one of them was very judicious with it. And the other one spent it in about 6 weeks and then called her mother and said, "Why did you let grandma leave me this money?" So if you've got minor children, I definitely think you need a trust. Absolutely.
Debbie, what do you tell family members? I'm sure you've had this already when they want to contest the will.
I'll give you the name of a really good litigator. That's the first thing I tell them, which I probably say flippantly and seriously. I think the biggest thing I tell them is you need to be willing to pay a huge emotional price if you want to contest this will, because it's very expensive financially. Anything like that, which is going to go to court, is going to have a substantial retainer. I've heard minimum $5,000 to $10,000, and you have to have that money. And unless you have really solid evidence that there's been undue influence by another family member or a caretaker, I mean, solid, it's not likely that you'll prevail. Mm-hmm. And you'll probably ruin a lot of relationships in the process. Now, I've not had anybody call me about that who's talking about millions of dollars. I really don't know what I would advise them if we were talking about millions of dollars. But I've had people who've talked about like $50,000, maybe a house. But again, that's money up front. There's no guarantee to win, and it could take years. Have somebody call me last week who was sure that she was due property from her grandfather's estate. And we traced the sale of the property over the last 30 years, and there didn't seem to be anything untoward in it. And I'm not saying her grandfather didn't leave her anything, but she's waited 39 years to even bring it up. So she hasn't had any conversation with her step grandmother in all those years. And I said, you can do what you want. I don't think there's anything here. And if you find somebody who's going to take it, it's going to be very expensive. So I think she decided to just let it be. I said, you don't know that. She said, my grandfather would have left me this house because. I said, I believe you. And you don't know that. You don't have a copy of the will. You don't have a copy of the trust. So I don't believe in will contests, and I know I won't do them.
But there's a question we just got from, they don't do names like YouTube. They have like these handles, but this right. is Mary One Kenobi.
Okay.
Great show. I'm wondering, what do you tell your clients if they want to do the will themselves? What are the downsides of that?
I just finished an article. I started naming it No to DIY, and I was told, no, make it maybe no to DIY. So what's the downfalls? You cannot be sure. The do-it-yourself platforms are unlikely to ask you follow-up questions. So for instance, you set up your will and you want to name your brother to be the personal representative. Your brother is 15 years older than you, and you're already 50. There's no promise that your brother will want to do that when you die, or will even be there to do that. And a do-it-yourself platform is not going to ask you, are you sure? They're not going to even ask you how much older than you is your brother. How old are you? How much older? So you wind up making decisions that look really good and aren't. You do a will and you say, my children get all split equally all of my assets, and you don't put in there something like per stirpes, which means if one of them dies, it goes to their children. So it means that, and you don't put something called rights of survivorship. So what you do is you have 4 children, Manny, Mo, Jack, and Teresa. Those are my father's 4 children. None of us were named Manny, Mo, Jack, or Teresa. But anyway, you have 4 children, Manny, Mo, Jack, and Teresa, and you say each of them get an equal share. You make no provision for Mo's children to get his if he dies. So that goes to probate. And you don't say that if Manny dies, that his share is split between the others. So you run all these risks that somebody who knows the questions to ask could help you prevent when you do it yourself. And the last thing I learned recently, I mean, there's more, but the last thing I learned recently, had somebody do a will for his dad. He downloaded it and it was done really, really well until it got to the place where it was notarized. In Florida, a will doesn't need a notary, but if it doesn't have something called a self-proving affidavit, it becomes more problematic to negotiate if you do need probate. And that notary block was incorrect, which effectively made the will problematic if there's anything in his father's estate that needs to go to court. So that's just 3. I get the temptation. I really do get the temptation. But I'll tell you what, there's a really great national program out there called, I never remember anymore if it's Prepaid Legal or Legal Shield, but for $27 a month, you can join. It's available in all 50 states. And as part of your membership, they give you a will and advance directives. And they're boilerplate. They're not custom. If you want custom, you have to get a referral, but they're issued by state licensed lawyers in whatever state you're in, so you know that they're current in terms of law. Don't do it. Don't do it yourself. And if you want a copy of the blog I'm going to get, somehow get Steve your email address and I'll be happy to send it to you.
Here's another from TikTok. Great show. I'm so glad I found it. I'm wondering, I just put money into this Trump account for my grandson. Do I need to have my estate plan reworked because of that?
You're breaking up, Steve. So he put money into a Trump account that he needs to have what? Yes, read that again. Does he need to what?
They have a Trump account. They just put $1,000, that there was $1,000 put in.
Yeah.
They want to know, do I need to go back and have my estate plan redone to include this?
Okay. So you put it in there for your grandchild. So here's the thing. The account needs a beneficiary. I mean, I'm not sure how they're being set up. So, but it needs a beneficiary just in case the grandchild predeceases. And if you've got and you don't want the child to get that money when they're 18 or whatever the rules are, you want to put it in a trust so that the trust manages that money. But the biggest thing is, I don't know that you have to go and redo your estate plan. You want to talk to whoever did your estate plan about that. I'm sure that if they're not familiar with Trump accounts, they're going to get familiar with Trump accounts. And then, but the biggest thing for me with any account like that is you got to be sure it has a beneficiary designation. Just don't leave it out there for the grandson, or it has a successor trustee if you're no longer around to manage it. Great question.
Another one from TikTok, a lot of them from TikTok this morning. They want to know, here's a person who lives in New Jersey 6 months out of the year, and they live in Tampa 6 months out of the year. Should I have a Tampa or a New Jersey attorney to do my estate plan?
Great question. Okay, so it depends. You need your estate plan and wherever your driver's license is. So if you're snowbirds and you have a New Jersey driver's license, your basic estate plan should be in New Jersey, done by a New Jersey attorney. If you're in Tampa 6 months in a year, I recommend that you have a Florida power of attorney and Florida advance directives, because you don't want to go to an institution or a doctor in a state that's not familiar with the documents you have from a different state. So your basic plan should be done in New Jersey, if that's where your driver's license is, and you could find a Florida attorney to do a power of attorney for financial decisions and healthcare directives for the same reason, so that when you give somebody something, they're familiar with it. You don't want some clerk turning it down because they've never seen a piece of paper before. You don't want some legal department turning it down because they've never seen a piece of paper before. And they need to be executed to Florida standards. So for instance, North Carolina demands that healthcare directives be notarized. Florida does not demand that they be notarized, as an instance. So if I've done documents for somebody who's going to spend time in North Carolina, I'm going to be sure that those documents are notarized so they at least have something to start with if they need it. And then I recommend they get their own North Carolina documents. But your basic plan should be in the state where your driver's license is. And anything else can be done for just support documents in the state that you're in 6 months a year. Rebel's going to cut us off, and we're only at 20 minutes.
Last question is, what is a living will?
Great question. So a living will is a document that is part of your advanced healthcare directives. A living will is a document that you sign that says what you want if you're in a state where there's no reasonable medical probability of recovery. The three categories on the living will are terminal condition, stage 4 cancer, end stage, which is like kidney failure, maybe congestive heart failure, or a persistent vegetative state. And your physician and a consulting physician say that there's no reasonable medical probability of recovery. At that point, you can say when you want any kind of life prolonging measures withdrawn. That's a living will. That's the living will. And you want to have one. Yeah.
God, your show goes by so fast, Debbie.
So
Debbie
fast.
Is the last Monday of the month at 9:00 Eastern time. We also replay her show throughout the month. Debbie, tell people how they can reach you.
Okay, so my phone number is 813-586-1332, 813-586-1332. I don't practice anywhere but Florida, but I'm happy to talk to anybody if they just want some advice on how to ask questions or whatever. And my email address is Deb Baker, DEBBAKER at London, like the city, LONDON, bakerlaw.com. And the person who asked about the DIY series, if you send me an email, I'd be happy to be sure you get a copy of the blog.
Beautiful. Debbie, we love when you come on the show.
Pink or not.
We were blessed the day we signed you up. Debbie will be back in with us next month. Debbie, have a wonderful week. And hey, no hurricanes, right?
No hurricanes. All right. And Rebels, stay safe.
Yes.
Okay. All right. Thanks, everybody. Talk to you soon. Bye.
Thanks, Debbie.
Sure.
That's attorney Debbie Baker. She's an estate planning attorney in Tampa, Florida. Amazing. We're going to go to a break. We'll be right back.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.